Hello. Good evening, one and all. Today we have Sandeep Chandrasekharan sir, Joint Secretary, LJRF State Chapter, as resource person. Welcome, sir. In the last class, we
Thank,
dealt with citizenship, nationality, and immigrants. Today we are going to discuss with loss of nationality, asylum, and refugee. I am handing over the section to Sandeep, sir.
I think we have already discussed different scenarios where you will lose your nationality. I think. No, in the last class it was about that. That is, opting for any foreign citizenship or any foreign employment uh, in the service of foreign government or acting against the interest of the state. There were different scenarios where your citizenship can be taken away by the state government. Okay, so I believe that up to that we have discussed, and now what we are going to discuss today is with regard to this concept of asylum, refugee, and statelessness. So in the last class I have. In relation to how nationality is obtained, we have discussed the different nationality can also be taken away. Now, there are also situations like asylum, refugees, where your nationality is still intact. Okay, but your status uh, is the status of uh, asylum seeker or refugee is a status that you have outside your country. Okay. So at the end, I believe you will wind up by speaking about the situations where you can become stateless person. Okay. So usually asylum seekers, refugees, stateless persons come into existence when there is a conflict within a country. Whenever there is a conflict within a country, uh, different, I believe, individuals within those countries, citizens within those countries may get affected, and they will be forced to flee from that country.
സർ
Okay.
പറയുന്നത് ക്ലിയർ
So there
ആവുന്നില്ല.
is some,
ചെറിയൊരു ബസ് ഫീൽ ഉണ്ട്, അതാണ്.
okay, break out.
ബ്രേക്ക് ആവുന്നില്ല സാർ, പക്ഷെ ഒരു ബസ് ഫീൽ ഉണ്ട്, അപ്പൊ അതാണ്.
ഒരു മിനിറ്റ്. ഇപ്പൊ എങ്ങനെയുണ്ട്? ക്ലിയർ ആണോ?
ക്ലിയർ ആണ് സാർ, ക്ലിയർ ആണ്.
ഓക്കെ ഒരു മിനിറ്റ്. ഞാൻ നേരത്തെ ഹെഡ്സെറ്റ് ഉപയോഗിക്കുന്നുണ്ടായിരുന്നു. സോ ഐ ഹോപ്പ് നൗ ഇറ്റ്സ് ക്ലിയർ. ഓക്കെ. So the peculiarity of asylum seekers, refugees, and stateless persons are that they are citizens of a country who are fleeing from that country due to certain political, economic, social instability, or due to a civil war, or due to a war with another country. Okay. So that is the common factor between all the three status of an individual outside his or her country. But at the same time, they are very much different. Okay, there are a lot of difference between asylum seeker, a refugee, and a stateless person. Not all asylum seekers are refugees. Okay, and not all refugees are asylum seekers. At the same time, not all asylum seekers or refugees are stateless persons. So I will explain what is the difference between an asylum seeker, what is the difference between a refugee and a stateless person. Okay, so that is the task that we have today. Now, based on the gravity of the situation, based on the severity of the status, I will grade them like asylum seekers first, then refugees, then stateless person. Okay, asylum seekers is a less severe situation. Refugees are more severe than asylum seekers. Then stateless person is the most worst situation. Okay, a person can imagine. Let me start with asylum seekers. What are the principles under international law that governs the concept of asylum seekers? So let me share the slide with you first. Another peculiarity is that in the syllabus you learn during your LLB, that is international law. All of you have international law as your paper. But in that international law, you don't pay much attention to law of war. So, okay, the most of the syllabus cover law of peace. Okay, that is international law during peacetime. That is what you learn during your LLB days. And we do not pay much attention to the international law governing human interactions during war. Okay, war or any other form of conflict. Now, 1 minute. Let me share the slide. I am unable to share my screen. Everyone, it seems 1 minute. Sure. I am having a small problem with sharing my screen, it seems. I hope everyone can see. Can you see my screen?
Yes, sir. It is.
Okay. Now let me put it in full screen mode so it is visible to all of you. Yeah. So asylum seekers. So what is from where this has emerged? So asylum seekers, if you look into the etymology of asylum seekers, the word emerged from a Latin, its origin is Latin. That is the asylum, the word asylum is from Latin. And this Latin word originated from the Greek word asylon, which means freedom from seizure. Freedom from seizure. Seizure എന്ന് പറഞ്ഞാല് ഫ്രീഡം ഫ്രം സീഷർ എന്ന് പറഞ്ഞാൽ നിങ്ങളെ പിടിച്ച് നിർത്തുന്നതിൽ നിന്ന് ഫ്രീഡം നേടുക, അതായത് ഫ്രീഡം ഫ്രം സീഷർ, പിടിച്ചു നിർത്തുന്നതിൽ നിന്ന്, അല്ലെങ്കിൽ നിങ്ങളെ തടയുന്നതിൽ നിന്ന് നിങ്ങൾക്ക് സ്വാതന്ത്ര്യം നേടിക്കൊടുക്കുക എന്നുള്ളതാണ് അസൈലം എന്ന് പറയുന്നത് വഴി ഉദ്ദേശിക്കുന്നത്. ഓക്കെ, സോ ടു ഗിവ് എ പേഴ്സൺ ഫ്രീഡം ഫ്രം ബീങ് stopped or prohibited or or being stopped from moving. That is what the word asylum means in the Greek and Latin terminology. Okay, so there is a lack of uniformity in the definition of asylum. Okay, if you look into what is the definition of asylum under international law, there's a lack of uniformity among the scholars, among the legal scholars of international law. And there is a reason why there is a lack of uniformity. It is due to political reasons. It is also due to a certain extent geopolitical interest. Okay, I will come to why it is so. So if you want to have a definition, a definition given by a prominent international scholar, Atlee Graham Madison. Graham Madison is a legal scholar, and he has written a thesis that is Territorial Asylum, which was published in 1980. And according to him, the components of asylum, which is a customary practice, okay, it is acknowledged as a customary practice among states. And if you look into the specific manifestation of state conduct, okay, the customary practice, international customary practice can be identified by looking into what the state is doing or not doing. And if you look into the actions and omissions of states, the customary practice of asylum can be summarized into 5 pertinent points. Okay, so asylum, under the definition of asylum, will include to admit a person to the territory of a state. Okay, so asylum is a transaction between a state and an individual who is living outside that state. Okay, so in this context, asylum, first salient feature of asylum is that it includes the prerogative of the state to admit a person to its territory, and second one, to allow the person to sojourn there. Sojourn means to stay there. Okay, to allow the person to stay there within its territory, to refrain from expelling the person outside its territory. Once the person is inside and he or she is allowed to stay, no entity can expel that person from the territory of the state. Okay, and the fourth one is to refrain from extraditing the person. Extradition means to send that person to another country. Okay, I hope you mean, I hope you understood. The difference between point number 3 and point number 4 is, point number 3 is saying the person cannot, once the person is permitted to come into the territory and allowed to stay in that territory, no one shall force that person to go outside the territory. Okay, and the fourth one is, no person, that particular person shall not be forced to go into another country. That is extradition. Extradition is the sending of a person from one country to another country for facing criminal charges. That is extradition. Extradition is another customary practice under international law that is utilized when you are transporting one criminal fugitive from one country to another. That is an extradition. So he shall not be extradited for any criminal offenses once he is given asylum. Okay, and the final one is, the fifth point is to refrain from prosecuting, punishing, or otherwise restricting the person's liberty. Okay, once the person who has come to the territory as an asylum seeker, he shall not be persecuted under the criminal law of the state in which territory, in whose territory he is allowed to stay as an asylum seeker. Okay, once a person is granted asylum, the country which is giving asylum shall not persecute or punish that person for any criminal offenses that he might have done outside its territory. Okay, I hope you understood. ആർക്കെങ്കിലും എന്തെങ്കിലും സംശയം ഉണ്ടോ ഈ പോയിന്റ്സിൽ? Is there any doubt? Can we move on? I hope you understood all the 5 points. Okay, fine. Now moving on to the next one. Now the component of
അവിടെ ഒരു ചെറിയൊരു ക്വസ്റ്റ്യൻ ഉണ്ട്. രണ്ടാമത്തെയും മൂന്നാമത്തെയും പോയിന്റ് ഒന്ന് റിപ്പീറ്റ് ചെയ്യണമെന്ന് പറഞ്ഞിട്ടുണ്ട്. ഇനി ഇത്
രണ്ടാമത്തെ മൂന്നാമത്തെ അല്ലേ? ഓക്കെ. അവിടെ ഈ രണ്ടാമത്തെ പോയിന്റ് എന്ന് പറഞ്ഞാല് ഇവിടെ ഒരു ഓൾഡ് ഇംഗ്ലീഷ് ആണ് ഉപയോഗിച്ചിരിക്കുന്നത്. സജോൺ Sajjan എന്ന് പറഞ്ഞാല് to have a residence. Okay. ഒരു അസൈലം സീക്കർ ഒരു രാജ്യത്തിന്റെ ടെറിട്ടറിയിൽ, അതായത് ഒരു ഫോറിൻ കൺട്രിയുടെ ടെറിട്ടറിയിൽ വന്നിട്ട് അസൈലം സീക്ക് ചെയ്യാണ്. ആ അസൈലം സീക്ക് ചെയ്യുന്നത് എന്തുകൊണ്ടാണെന്ന് ഐ വിൽ കം ടു ദാറ്റ്. അപ്പം എനിവൺ നോസ് വൈ അസൈലം ഈസ് സീക്ഡ് ബൈ ഇൻഡിവിജ്വൽസ്? എന്ത് പർപ്പസിനാണ് നമ്മൾ അസൈലം സീക്ക് ചെയ്യുന്നത്? എനിവൺ ഹാസ് any answers? നമ്മൾ എന്തുകൊണ്ടാണ് അസൈലം സീക്ക് ചെയ്യുന്നത്? I hope you might be to escape from persecution. Okay, fine, correct. What kind of persecution we need? There are different kind of persecutions, right? So when you say persecution, what do you mean by persecution? That is not criminal. That is not criminal, political or political persecutions. Correct. Advocate Reshma has mentioned as political persecution. So you seek asylum from political persecutions that you might be facing within your country. Okay. Can anyone give me an example of an individual who sought asylum in a particular foreign country? Dalai Lama, very good. Vineet Kumar has mentioned Dalai Lama. Dalai Lama, who was the spiritual leader of Tibet, sought asylum in India when he was when Tibet was conquered occupied and annexed by China. And the political establishment took over. The communist political establishment took over administration of Tibet. So that is a good example. Then there is Taslima Nasri is there, who is a political activist, writer, author from Bangladesh, I believe. And she is also a classical example of a asylum seeker, and she was persecuted for her views on Islam. And we have our own asylum seekers in India. Can anyone name an asylum seeker who is from India? Any examples of anyone who is seeking asylum from India? That is an Indian citizen who is seeking asylum in outside foreign country. Do you know a painter, a famous Indian painter, Hussain? There's I forgot his full name. His name is Hussain. He is a Muslim person who was born in India, and he used to paint depictions of Hindu gods. And his painting depicting Hindu gods were most of them were very nude. M.F. Hussain, correct. Sigma Das has mentioned M.F. Hussain, and he used to draw Hindu gods in pretty much. I don't know what word should I be using. Nudity. It was an artistic expression, and he did not intended to infringe the religious sentiments of Hindus, and he used to paint Hindu gods with all due respect to the religion, and some Hindu groups took offense to his painting, and he was threatened. His life was threatened within India, and he had to escape from India, and he sought asylum in foreign countries, I believe, and eventually he got citizenship in Switzerland, in one of the Scandinavian countries, and he died then and there. M.F. Hussain is a classical example of an asylum seeker. So you understand that is political people who are escaping from political persecution, and political persecution may be an individual may be politically prosecuted for having a political point of view, for having a religious point of view. for having philosophical point of view. So usually political asylum seekers have a difference of perspective when it comes to religion, culture, politics, and ideology. For these reasons, individuals will seek, for these difference of opinion or difference of perspective, individuals may face punishment or prosecutions within their country, and they may need to escape from their own country along with their family members in order to save themselves. And these are the situations in which asylum is sought. So asylum is a very controversial topic in itself. So that is the reason why there is a lack of universally accepted definition when it comes to what constitutes an asylum. And the problem of that lack of uniformity in the definition is also reflected in the way in which international law tries to articulate what, under which situations a person can seek asylum, who is an asylum seeker, who has the right, who has the duty. All these things are also very much ambiguous because of its political nature. Okay, because of its political characteristics, asylum is something that is a little bit controversial in the international community. And regardless, we have to look into the international norms to see what we have with regard to asylum. Okay, we have to keep in mind the political aspect. At the same time, we have to appreciate what is there in the legal term. So the international law, international legal principles regarding asylum can be divided into two aspects. First aspect is the right of the state to grant asylum, and the second aspect is the right of an individual to seek asylum. Okay, so when you are studying asylum, the subject of asylum, it can be divided for academic purpose. It can be divided into two compartments. One is the compartment of right of a state to grant asylum, and the other one is the right of an individual to seek asylum. Okay, so we will first look into right of a state to grant asylum. Okay, now the first point that you have to take into consideration is that every sovereign state is deemed to have exclusive control over its territory, and hence over persons present in its territory. This is a basic understanding. Okay, that is what you mean by sovereignty. Okay, a state has complete control over whatever there is in its territory, whether it is an individual or any movable property or immovable property. Whatever that comes within its territory, the state has absolute control over those subject matters, with a few exceptions here and there. Okay, this is the general rule, but there are exceptions. An exception that might come to your mind is law relating to diplomacy. That is international law in relation to diplomacy or diplomatic immunity. The individuals who are enjoying diplomatic immunity, they gain immunity from the state sovereignty. That is the sovereignty of the state in whose territory those diplomats are functioning. Okay, that is an exception. Okay, so whenever there is an immunity, there is a liability. Okay, that is Hoffi's diagram of rights and duties. I hope you remember. No, not liability, that is immunity means no power, not a liability. The corresponding the concept is no power. When there is diplomatic immunity, the country in whose territory that diplomat is located, the country does not have any power to exercise its sovereignty over that diplomat. Okay, So that is a particular exception that we will talk into, I believe, in the coming classes. But kindly keep in mind, otherwise the particular country has absolute control over its own national as well as foreigners within its territory. Okay, the next important thing that you have to take into account is that every sovereign state has the right to grant or deny asylum to persons located within its boundary. Okay, under international law, it is acknowledged that every sovereign state has the right or prerogative to grant or deny asylum to a person located within its boundary. That is what international law is saying. Where it is mentioned, you have to look into Article 14, Clause 1 of UDHR. Okay. So Article 14, Clause 1 of UDHR says that every person has the right to seek and enjoy in other country asylum from persecution. Okay. So again, kindly note the wording that is used. Every person has the right to seek and enjoy. Okay, that is the wording. Every person has the right to seek and enjoy in other countries asylum from persecution. So that is the first international convention that directly acknowledges the customary practice of asylum. That is the UDHR. UDHR is the first international document that acknowledged the concept of asylum under international law. Prior to UDHR, it remained as an international customary practice that was not codified. Okay. So kindly remember, Universal Declaration of Human Rights is a soft law. It's not a hard law. I hope you remember in our last classes we have discussed, when we studied international treaties, we have discussed about soft law and hard law. Okay, soft law are those laws which are not legally binding. Okay, they are mere declarations of already existing customary practices under international law. And the peculiarity of international customary practices is that they are followed voluntarily. Okay, there are no enforcement mechanisms for international customary practices, and soft laws like the Universal Declaration of Human Rights and many other declarations made by the General Assembly resolutions, they are a declaration of existing international customary practices, and they are not legally binding. They can be followed voluntarily. Okay, that you have to keep in mind. Also try to recall the difference between soft law and hard law. Hard laws are conventions which are legally binding to the parties to the convention. Okay, soft law are mere declarations which are not legally binding. Okay, so UDHR is a soft law, and under Article 14, Clause 1 of the UDHR, it says that every person has the right to seek and enjoy in another country asylum from persecution. So what kind of persecution we are talking about? That nature of persecution is mentioned under Article 14, Clause 2 of the Universal Declaration of Human Rights. Okay, so it says that the right to seek asylum may not be invoked in cases of persecutions genuinely arising from non-political crimes or from acts contrary to the purpose and principle of the United Nations. Okay. So any asylum cannot be one cannot seek asylum for non-political crimes or for any act contrary to the purpose and principle of United Nations. Okay, so one cannot seek asylum for committing a terrorist attack. Okay. One cannot seek asylum for committing a terrorist attack, for example. Terrorism is something that is acknowledged as an offense against the whole of humanity by the United Nations. One cannot seek asylum for committing piracy in the sea or in the high seas. Okay, these are classical examples of acts which are contrary to the purpose and principle of United Nations. A piracy committed on the high seas are a classical example which prohibit the person who has committed piracy from seeking asylum. One cannot seek asylum for committing crimes against humanity. Okay, if any person has committed any crimes against humanity under humanitarian law, under international humanitarian law, or international criminal law, okay, he cannot seek asylum. Okay, and a person who is a Nazi officer who was in the concentration camps like Auschwitz, they cannot seek asylum for the war crimes that they have committed. These are classical examples of acts which are contrary to the purpose and principles of United Nations. Okay, and you cannot seek asylum for non-political crimes. You cannot seek asylum for killing a civilian. Okay, for killing or murdering children, you cannot seek asylum. If you have committed any fraud, any financial crime, you cannot seek asylum. Okay. Very recently, Vijay Mallya had sought asylum. Nirav Modi, Vijay Mallya, both of them have attempted to seek asylum in United Kingdom, saying that what is happening in India against them is not a criminal investigation, but political persecution. Okay, that is the argument made by Vijay Mallya and Nirav Modi before the judiciary in United Kingdom, and that was nullified. That okay, the court held that the actions taken by the Indian state, Union of India, the actions taken by Union of India is not in the nature of political persecution, but they are in the nature of pure financial fraud that has been committed by both of the parties. This is a classical example. Okay, you have to genuinely differentiate between what is a political the persecution and what is not a political persecution. Unfortunately, what constitutes a political persecution and what not constitutes a political persecution is not defined in the international conventions or any declarations as such. But you have to ascertain the same from precedents that are set in different countries. Okay, so kindly remember the political persecutions are in the nature of in the nature of political ideology, religious ideology, cultural ideology, and everything else is not political persecutions. Okay, so I have also mentioned the asylum case, otherwise known as Colombia versus Peru, judgment before the International Court of Justice. This particular case is used in your LLB syllabus when you are discussing diplomatic immunity under international law. Okay, so in this particular case, the Peruvian government, in one of their diplomatic buildings located within Colombia, the Peruvian government gave asylum to a particular individual fleeing from political persecution within Colombia. Okay, so this particular individual, he was alleged to have conspired to commit a political assassination of one of its leaders, and he sought political asylum within the diplomatic complex that was located within Colombia, and Peru accordingly gave him asylum. Here the gist of the case is whether Peru can give asylum within its diplomatic premises located within Colombia. And ICJ held that the Peruvian government can grant asylum within its diplomatic premises because it is a local custom. It is a local custom which existed among the South American countries. Okay, so this is a precedent that was set by the ICJ with regard to local custom. This particular case we have already discussed in our previous classes when we discussed sources of international law. That is international custom. International custom can be divided into local custom. Local custom is the customary international practices which are practiced within a region. Okay. So in South American countries, it is a international customary practice to grant asylum within the diplomatic premises of a particular country located in the territory of another South American country. Okay, this is a customary practice. Because of this was so because of the political instability within South America. So the South America was a political hotbed for the fight between the capitalists and the communists. Okay, in many South American countries there were dictatorships supporting capitalism. In another neighboring South American country, it will be a dictatorship supporting communism. So the Cold War that was happening between the Soviet Union and the Western countries physically manifested in many of the regions of the world, and South America was one among them. So it was due to the political instability that was there in South America. Many countries were forced to give political asylum to fugitives within their neighboring countries through their diplomatic embassies. Okay, that is a particular case. I just want to refresh upon it. So in this particular case, the individual committed a political assassination of a leader of Colombia. He was a dictator who supported communism, and Peru was a country who supported capitalism. So this this individual who was part of a conspiracy to assassinate the communist leader, he was a capitalist. So it was in the interest of ideological interest of Peru to grant asylum to this particular individual. Peru also gains relevance with regard to Julian Assange. Very recently, Peru gave in 2012. Peru gave asylum to an individual named as Julian Assange in UK. He was an Australian citizen. He was given asylum by the Peruvian government in its UK embassy. Okay, so Mr. Assange went to the UK embassy of Peru, seeking asylum from extradition to United States. Okay, Julian Assange was facing criminal charges for leaking diplomatic cables which exposed war crimes committed by United States in Afghanistan and Iraq. Okay, through his online website named as WikiLeaks. So Julian Assange, who was an Australian citizen who was living in United Kingdom, he was charged with waging war against the United States by leaking confidential diplomatic cables which exposed war crimes committed by United States in Afghanistan and Iraq. Okay, so he was about to be extradited to United States. Before the UK authorities could extradite him to United States, he came to Peru. He came to the Peruvian embassy, which was located in London, and Peruvian government granted him asylum within its embassy. Okay, the embassy is a 2-story building, around 400 square meters. And he stayed in the Peruvian embassy, Peruvian UK embassy for around 10 years. Okay, this particular individual stayed in the embassy for 10 years. He could not move outside the Peruvian embassy. If he moved from outside the Peruvian embassy, he would have been arrested by the UK police and extradited to United States. Okay, so kindly remember the 5 principles I have mentioned. What the Peruvian government has done is it has treated its embassy as part of its territory. Okay, so once Julian Assange was given asylum within the Peruvian embassy, within the customary practice of international law, no one can force Julian Assange to move outside the Peruvian embassy, not even the UK police. Okay, not even the UK police can come inside the diplomatic complex and force him to move outside the diplomatic embassy. Peruvian government can do this because of the local customary practice which is existing in South America. Otherwise, they cannot do. Under the international law governing diplomatic embassy, you should not use your diplomatic premises for granting asylum or accepting any refugees. That is the norm. That is the norm under the Geneva Convention on Diplomatic Immunity. Okay, Vienna Convention on Diplomatic Immunity. There is a convention governing diplomatic immunity, and that is the Vienna Convention on Diplomatic Immunity, and it says that you cannot use diplomatic premises for granting asylum. It is expressly prohibited. But the South American countries can do this because it is a local custom that is existing in the South American countries. And this Peruvian Julian Assange's case can be looked into in order to understand the scope and ambit of asylum. Okay, the Peruvian government has given asylum within its diplomatic premises, and no one can remove Julian Assange from the diplomatic premises other than the Peruvian government. Okay, it is a prerogative of the Peruvian government whether to grant or not to grant the asylum to Julian Assange. And finally, in 2021, I believe, in 2021 or 2020, Julian Assange's asylum was withdrawn by the Peruvian government, and the UK police came inside the diplomatic premises of the Peruvian government and arrested Julian Assange, and he was extradited to Sweden. Okay. So that is the case of Julian Assange. That is the case. That is the asylum case. Again, keep in mind all these case laws. Now, moving on. What is the right to grant asylum in relation to a state? You kindly look into the Declaration on Territorial Asylum adopted by the General Assembly of the United Nations in 1967. So this is another soft law with regard to asylum. Okay, so under the declaration made by the General Assembly with regard to granting asylum in the territory of a country, in Article 1 of the declaration, Article 1, Clause 1 of the declaration made in 1967, it says that asylum granted by the state in exercise of its sovereignty to a person entitled to invoke Article 14 of the Universal Declaration of Human Rights shall be respected by all other states. Okay, so if India has decided to give asylum to Dalai Lama for escaping political persecution from the Chinese Communist government, all countries, including China, shall respect the same. Okay, that is what the General Assembly Declaration on Territorial Asylum is saying. Okay, it is again declaring an existing international customary practice. Okay, so that is there in Article 1, Clause 1 of the Declaration on Territorial Asylum adopted by the General Assembly. This is basically a General Assembly resolution made in 1967. Again, if you look into Article 1, Clause 3, it says that the state has the authority to evaluate the grounds for granting asylum. Okay, so when India or Peru is trying to decide whether or not to grant asylum, it is the state which is granting asylum to decide whether there is the particular individual who is seeking asylum is trying to escape from political persecution or not. So who defines what constitutes political persecution? It is the state which is granting asylum who decides or who defines what constitutes political persecution, and what does not constitute political persecution. Okay, it is up to the state authorities to decide whether a particular individual is facing any political persecution or not. Okay, that is what Article 1, Clause 3 is trying to say. So example of the implementation. This particular declaration has been implemented in many of the regional conventions of many regional organizations. Okay, so keep in mind this declaration on territorial asylum is a soft law, and soft law often transforms into, or it is often the principles of soft law is incorporated into many international conventions, which is a hard law. Okay, so the principles of declaration on territorial asylum, it has been incorporated by many regional organizations within its regional conventions, within their respective regional conventions, which are hard law. Which hard law means international conventions which are legally binding. So one of the hard law, one of the regional hard law is the American Declaration of Rights of Duties of Men, Rights and Duties of Men. Okay, there is the American Declaration of Rights and Duties of Men. That is made by the regional organization of South American countries. So in this American Declaration of Rights and Duties of Men, under Article 27, it says that every person has the right, in case of pursuit not resulting from ordinary crimes, to seek and receive asylum in foreign territory in accordance with the law of each country and with international agreements. Okay, that is when it says that every person who is seeking asylum has the right to seek and receive asylum in foreign territory according to the law of that country. Okay, so it's again, who should be given asylum, who should not be given asylum, it is up to the country to decide. It is up to the country who is giving the asylum to decide. Okay, there is, in other words, there is no guarantee that the person who is seeking asylum, he or she will be getting the asylum. Okay, there is no guarantee. It is up to the discretion of the state to give asylum or not to give asylum, by interpreting what constitutes political persecution, what does not constitute political persecution. So again, that is the reason why initially I mentioned that there is no unified definition of there is no unified definition for asylum under international law, because there is a disagreement as to what constitutes political persecution. Political persecution, which is an important component of asylum. Okay, again, if you look into another regional convention, that is the American Convention on Human Rights. If you look into Article 22, Clause 7 of the American Convention on Human Rights, it says that every person has the right to seek and be granted asylum in a foreign territory in accordance with the legislation of the state and international conventions. Okay, again, what does it say? What does it say? It says that every person has the right to seek asylum, and it is not guaranteed that the person will be given asylum. Okay, every person has the right to seek asylum, and at the same time, he or she may or may not be given asylum by the country. Okay, it is up to the country to decide through its statutes to interpret what constitutes political persecution. Again, it is reiterated in the American Convention on Human Rights. That is, the same thing is mentioned by the Declaration on Territorial Asylum by the General Assembly resolution. If you look into Article 14, Clause 1 of the Universal Declaration of Human Rights, it doesn't say, the wording in Article 14, Clause 1 does not guarantee that a person shall be given asylum. it says that a person can seek asylum. And the wording is enjoy. Okay, the person can seek and enjoy. It does not use the word guarantee. Okay, or it does not use the word shall. A person shall be given asylum. Okay, what is guaranteed is a person can apply for asylum. You can fill a form and give it stating the reason why you are seeking asylum in United States, United Kingdom. And after receiving the form, the government will go through the form and try to, it is up to the particular tribunal that may be constituted, or particular bureaucratic agency that may be constituted under the particular municipal law of the country to decide whether to give you asylum or not. Okay. That is a peculiarity of the concept of asylum under international law. Again, another convention I would like to mention, that is the regional convention of the Organization of African Union. Okay, otherwise known as African Union. In short, it's known as African Union. So African Union is another regional organization, and they have drafted the convention governing specific aspects of refugee problems. And under Article 2 of 2 Clause 1 of the particular convention, it says that member states shall use their best endeavors consistent with their respective legislation to receive refugees. Okay, again, it does not mention the word as asylum seekers. So I have mentioned that all asylum seekers are refugees. In a way, they are also refugees, but not all refugees are asylum seekers. Okay, so here also impliedly they cover asylum seekers. Again, whether it is an asylum seeker or a refugee, the prerogative to grant asylum or refuge is up to the country concerned. Okay. Now, another, again, I have also quoted many other conventions which says the same. That is the Asian African Legal Consultative Committee. They have made a declaration on the principle concerning treatment of refugees. And within this principle, Article 3 Clause 1 of the principle states that a state has the sovereign right to grant or refuse asylum in its territory to a refugee. Okay, so it expressly makes it very obvious what is meant by to what extent a country can exercise its powers to grant or not to grant asylum. Okay, this particular principle that has been proclamated by the Asian African Legal Consultative Committee. So this is in 1966. Okay, this committee, it's again a regional organization, and they have declared, they have this organization through a declaration. Again, this is a soft law, not a hard law, but a soft law which makes it very obvious that it is up to the state to grant or not to grant asylum. Okay, it is not up to, and asylum is not guaranteed to any individual. Okay, so again, in 1977, the Committee of Ministers of the Council of Europe also took a similar line. Okay, again, what they have adopted is they have adopted a declaration on territorial asylum. Under this declaration on territorial asylum, under Article 2, it says that Article 2 reaffirms the right of the state to grant asylum. Okay, again, what is mentioned in the Asian African League of Consultative Committee, it is reaffirmed in the Declaration on Territorial Asylum by the Council of Europe. Okay, so I just want to make it clear that the right of the state to grant asylum, it is absolute. Okay, and an individual does not have any guarantee that he or she will be granted asylum. It is up to the state to whether to reject or not to give asylum to a particular individual or not, and it depends on the interpretation of what constitutes political persecution and what not constitutes political persecution. Now, coming on to the right of an individual to seek asylum. So, even though asylum is not guaranteed under international law, the individual has the right to seek asylum. If they can, at least they should be given an opportunity to make an application for asylum. Okay, that is what the current international law offers, unfortunately. Now, according to Graham Madison, a state may not claim to own its national or residents. Under international law, a national or a resident of a particular state is not under its ownership. Individuals are not objects of ownership by a state entity. That is generally acknowledged in the academia, in the legal scholarship with regard to asylum. And why it is so, we can see that in Article 13, Clause 2 of Universal Declaration of Human Rights. Why individuals are not under the ownership of any particular state. If you look into Article 13, Clause 2 of Universal Declaration of Human Rights, it says that everyone has the right to leave any country, including his own. That is what Article 13, Clause 2 is saying. So, if you feel threatened, or if you feel that you need to improve your economic prospects by seeking employment outside a country, you have the ability, or you have the freedom of movement from one country to another. That is what is guaranteed by UDHR. And that freedom of movement can be exercised to seek better prospects outside one's own country, or to escape, including to escape from political persecution. You can also move from your country to another country to escape from political persecution. Now, that is what is implied in Article 13, Clause 2 of UDHR. Again, this is a soft law. Universal Declaration of Human Rights is a soft law. And this particular freedom to move from one country to another, or the right to leave any country, including one's own country, it is acknowledged in many of the hard laws, that is conventions which are legally binding, which includes the International Convention on Civil and Political Rights. If you look into Article 12, Clause 2 of the International Convention on Civil and Political Rights, it says that everyone shall be free to leave any country, including his own. Again, what is mentioned in UDHR is again incorporated verbatim into the International Convention on Civil and Political Rights. So you can exercise this right, that is the right to leave any country, including your own, to seek asylum in any foreign country. Okay. Again, the same right to leave any country, including one's own, it is again acknowledged by many other hard laws, and one of them includes the Council of European Agreement number 46, Protocol number 4 to the European Convention for Protection of Human Rights and Fundamental Freedom. Okay, the protocol number 4 attached to the Council of European Agreement number 46. Again, that is attached to the convention, European Convention for Protection of Human Rights and Fundamental Freedom. It says that every person shall have the shall be free to leave any country, including its own. Again, the verbatim of Article 13, Clause 2 of UDHR is again incorporated here. Again, another example of a hard law which has acknowledged this right is the American Convention on Human Rights. Again, a regional convention under Article 22, Clause 2. Again, it is acknowledging every person has the right to leave any country freely, including his own. Okay, you can leave your country fearing political persecution. You can leave your country for better prospects. Okay, once you have left your country, you can make an application to seek asylum in another country. Okay, so this is all for today. I believe you have any doubt, we can discuss, and we can resume the rest of the class in another session. Okay, I have I think I have gone a little bit fast today. I hope you can understand. These are, I believe, provisions which are foreign to you, which is not included in your syllabus. In our syllabus does not give much focus to refugee law, asylum law, because it is a very controversial subject. Okay, even though I believe even if it is a controversial subject, if the academic relevance of legal subjects should be discussed freely, and I believe the law of war, that is the humanitarian law, the humanitarian law with regard to refugees and asylum seekers should be included in our syllabus. And if you look into the refugee conventions, including many declarations with regard to asylum, India is not a party to those declarations and conventions. Okay, India is conveniently it is not a party to not even a single convention on refugees or any declarations on asylum seekers. Okay, and I believe to a certain extent that may be the reason why not much focus has been given to the syllabus. It is my personal opinion, and it's not an opinion made by any others. So if you have any doubts, you can ask. Any questions, anyone?
Thank you, Sandeep sir. വളരെ നല്ലൊരു ക്ലാസ് തന്നെയാണ് സാർ ഇന്ന് എടുത്തത്. അപ്പം ആർക്കെങ്കിലും എന്തെങ്കിലും പോയിന്റിൽ ക്ലാരിഫിക്കേഷൻ ഉണ്ടെങ്കിൽ വേണമെന്നുണ്ടെങ്കിൽ ഇപ്പോൾ ചോദിക്കാം.
കൺഫ്യൂഷൻ വരാവുന്ന ഏരിയ ആണ്, പക്ഷെ ഇതിൽ നിന്ന് ചോദ്യങ്ങൾ വരും ഉറപ്പായിട്ടും. നിങ്ങൾ പല കൺവെൻഷൻസ് നിങ്ങൾ ആദ്യമായിട്ട് കേൾക്കുന്നുണ്ടായിരിക്കും. ഇത് ഇറ്റ് ഈസ് എ വെരി ഗ്രേ ഏരിയ. ഞാനിപ്പോ പറഞ്ഞല്ലോ, ഇത് ഈ നമ്മുടെ കൺവെൻഷൻ ഓൺ സിവിൽ ആൻഡ് പൊളിറ്റിക്കൽ റൈറ്റ്സിനകത്തും ഇന്റർനാഷണൽ കൺവെൻഷൻ ഓൺ സിവിൽ ആൻഡ് പൊളിറ്റിക്കൽ റൈറ്റ്സിനകത്തോ ഇന്റർനാഷണൽ കൺവെൻഷൻ ഓൺ എക്കണോമിക്, സോഷ്യൽ ആൻഡ് കൾച്ചറൽ റൈറ്റ്സിനകത്തോ അസൈലത്തിനെ കുറിച്ച് സംസാരിക്കുന്ന പോലും ഇല്ല. ഓക്കെ, അസൈലം എന്നുള്ളൊരു വാക്ക് ഈ രണ്ട് ഇന്റർനാഷണൽ ഹ്യൂമൻ റൈറ്റ്സ് കൺവെൻഷനകത്ത് മെൻഷൻ ചെയ്തിട്ട് പോലും ഇല്ല. ഓക്കെ, കാരണം എന്ന് പറഞ്ഞാല് ഈ ഒരു രാജ്യത്തിന്റെ ശത്രുക്കളെ ആയിരിക്കും അസൈലം വഴി രക്ഷപ്പെടാൻ ചാൻസ് ഉള്ളത്. ഓക്കെ, if you implement the international conventions, international customary practice of asylum through an international convention which is legally binding, what happens is you are giving an opportunity to your own enemy. Okay, an enemy may be an individual or a group of individual to escape from your hand and to seek refuge in another foreign country. Okay, നിങ്ങളുടെ ശത്രുക്കള് ചിലപ്പം പൊളിറ്റിക്കൽ ശത്രുക്കളായിരിക്കും. പൊളിറ്റിക്കൽ ശത്രുക്കൾ എന്ന് പറഞ്ഞാൽ ഫോർ എക്സാമ്പിൾ ഇപ്പം എന്താ പറയാ, ഒരു പുള്ളിക്കാരന്റെ പേര് ഞാൻ മറന്നുപോയി. നമ്മുടെ ഈ MF ഹുസൈനെ പോലെ റസ്തോർഗി, പുള്ളിക്കാരന്റെ പേര്, ഒരു പുസ്തകം എഴുതിയ ഒരു ആളായിരുന്നു, ഒരു മുസ്ലിം ആണ്. ഹി വാസ് ബോൺ ഇൻ പാകിസ്ഥാൻ. Zakir Naik. No, not Zakir Naik. Zakir Naik is a good one. You see, Zakir Naik is a Islamic scholar. He is acknowledged as a Islamic scholar by many Muslim countries around the world, especially the Gulf countries. And Zakir Naik is currently he has sought asylum in Malaysia from the Indian government. Okay, and the argument made by the Indian government is that he has preached against Indian unity. His preaching, some of the preachings compromise India's national security, India's public order, India's national integrity. Okay, some of the preachings he have made infringes religious harmony. These arguments were made by the Indian government, and many investigations and inquiries were made, and many of his assets were attached by the Indian government. And he sought asylum. Accordingly, he sought asylum in Malaysia. Okay, Zakir Naik is a good example. So again, so if asylum is made legally binding, you are giving opportunity for your own enemies, potential enemies, to escape from your hands of justice. Okay, for this reason, for this reason, all countries around the world, they have refused to come up with a legally binding convention, international convention on asylum. Okay, this is the prominent view that is held by many legal scholars in international law. So it's a very controversial subject, but it is there in your UGC syllabus. I believe in Indian government is giving more and more attention to law regarding asylum and refugee, because it may serve certain geopolitical interest of the government. Okay, you can use international law for your own geopolitical interest, and to that extent, the Indian government is doing a good job. It is, again, I'm just sharing my personal point of view. Any doubt, anyone? Any questions? I will resume. There are many more conventions that are 3 more conventions that are remaining before we wind up asylum. And after concluding asylum, we will go into who are refugees. Okay. After looking into refugees, we will go to stateless persons. Okay. So if you have no questions, we can wind up the class.
Yes, sir. Is it clear, sir? Is it clear?
Okay. Okay, very much. Good day. Good night.
Thank you, sir.